Good morning. This morning I'll be making an announcement on the conclusion of Mr David Bain's application for wrongful conviction and imprisonment. At the outset, let me say that this case has been one of the most complex, unique and high-profile cases New Zealand has ever known. While many New Zealanders hold strong views on the case, the complexities of the evidence and the opinions that the evidence have given rise to are such that those views are likely to continue to be firmly held without clear resolution. One thing on which I like to think we can all agree is that at some point, some finality needs to be achieved. This is a process that has been going on for many years. It's now more than 22 years since the murders took place, and nearly 6.5 years since the application for compensation was made. On the morning of June 20th, 1994, Margaret, Laniette, Arawa, Stephen and Robin Bain were found dead in their Dunedin family home. In March 1995, David Bain was convicted on 5 counts of murder in the Dunedin High Court. The case was then subject to a number of appeals and reviews, all of which were unsuccessful. Mr Bain then appealed to the Privy Council, who in 2007 quashed the convictions and ordered a retrial. The retrial resulted in Mr Bain being acquitted in June 2009. In March 2010, Mr Bain lodged his application for compensation with the government, who commissioned a report from retired Canadian judge Justice Ian Binney. That report was peer-reviewed by QC Robert Fisher, who found it to have included fundamental errors of principle such that it would be unsafe to act upon it. That finding was not accepted by Mr Bain's team. In February 2015, I reached agreement with Mr Bain that these 2 reports would be put aside and that Cabinet would take a fresh look at the claim. I subsequently appointed Mr Ian Callinan QC, a highly respected retired judge of Australia's highest court, to provide advice on Mr Bain's claim. I received Mr Callinan's draft report in September 2015, and in accordance with the process put in place at the time of Mr Callinan's instructions, the parties were then invited to make comment on the report before it was finalised. I received the final report from Mr Callinan on the 27th of January 2016. There have been ongoing discussions with Mr Bain's legal team since this time. Today I'm releasing Mr Callinan's report, which finds that Mr Bain has not established his innocence on the balance of probabilities. The test for compensation requires that the applicant proves on the balance of probabilities that they are innocent. This is a different and higher test than the one in the courtroom on which the acquittal was based. In court, the Crown must prove guilt beyond a reasonable doubt. It is sufficient if the defence can raise reasonable doubts that they're responsible for the offence. In light of Mr Callinan's advice, and the onus being on Mr Bain, there is accordingly no basis on which Cabinet could be satisfied that Mr Bain had met the established threshold for compensation for wrongful conviction and imprisonment. Accordingly, no statement of innocence or payment of compensation under the guidelines will be made to Mr Bain. However, the Crown recognises that the compensation application process has lasted nearly 6.5 years, and that this has been an incredibly difficult and complicated case for all involved. Reaching this point, I think it's fair to say, has taken longer than anyone would have wanted it to. In addition, since receiving Mr Callinan's final report, it's become evident that Mr Bain and his advisers do not accept Mr Callinan's findings. They have made it absolutely clear that they intended to legally challenge that report, leading to considerable further cost and delay in this matter. While the Crown is confident in the strength of its position in any such review, it's clearly desirable to bring finality to this case and avoid the cost and uncertainty of further proceedings. In my view, no one benefits from this matter continuing to drag on in continued litigation that would see more and more money spent in an effort to reach finality. That can't be in anyone's interests. In light of that, the Crown has agreed to make an ex-gratia payment of $925,000 in recognition of the time involved and expenses incurred by Mr Bain during the compensation process and the desirability of avoiding further litigation. Mr Bain has accepted this payment in full and final settlement of all matters. This resolution is, I believe, a pragmatic one that recognises the unique circumstances of this case and a desire on all sides to bring this matter to a close. Mr Bain's compensation claim has not been a quick or an easy process. If this conclusion hadn't been reached, the matter would very likely have dragged on longer, with no more likelihood of absolute answers than we have today. I think we can all recognise that this is a case like no other. Even Mr Callinan himself said he could not think of any other criminal case in which so many issues have been raised and in which there have been so many conflicts or inconsistencies of opinion and also of evidence. He went on to say that it was likely no one will ever know what happened. While the issue has divided opinion in New Zealand, I am satisfied that the matter has now at least been concluded. I want to thank Mr Callinan for his report. He is a highly respected jurist, and I'm grateful for his considered advice. I rely on his own words to conclude. People in real life and the courts that adjudicate upon conflicting facts know that all of the questions cannot always be answered and all of the issues neatly resolved. This is such a case.